Right, everyone. Good morning. Welcome to all of you. I am Roger Kuznia, DarrowEverett's Director of Marketing, and want to welcome you to our Corporate Transparency Act webinar with Michael Raposa in the speaker's chair. Michael is one of our tax and private wealth services attorneys, and we really appreciate him taking out the time today. Following Michael's presentation, we'll open up the session for questions. The way to ask those questions is just use the chat box to key them in, and Mike will answer as many as possible. Michael, the floor is yours, and thanks again for your time, and thank you for all attendees for coming.
Thank you very much, Roger. Well, welcome everyone to today's presentation on beneficial ownership information in the Corporate Transparency Act. The beneficial ownership information rule was propagated back in September 2022, but it is now time to actually start thinking about compliance as there are a number of deadlines coming up quite quickly. So as Roger mentioned, I'm one of the associates in the tax and private wealth management practice groups, as well as the energy and infrastructure practice group. I deal with private companies as well as private individuals, large public companies. Previously, I was at a large firm in Boston in their tax department, dealing with REITs and other financial investment vehicles. So by a bit of background, the Corporate Transparency Act was passed by Congress with the idea of increasing the amount of information available on entities formed in the United States for business purposes. At the time, the rule was actually propagated back in September of 2022. One of the things that FinCEN actually noted was that there were over 2 million entities registered to do business in the United States. So some of the primary concerns that Congress and FinCEN had when it came to all of these entities that were created is that many of these, there was very little oversight or very little knowledge of what they were doing or who had formed them. So there was a concern that for organized crime, for money laundering, for sanctions busting actions by foreign regimes, this was a weak spot in our defenses from a criminal justice standpoint and also from a security standpoint. So some of the classic examples relate to drug cartels, money laundering for organized crime, regimes like Russia, North Korea, or Iran trying to source American-made products in order to incorporate them into weapons or for some nefarious purpose. So when you hear about newly manufactured instruments from or materials from Texas Instruments in the United States being found in cruise missiles that were newly manufactured by the Russians and recently blew up an apartment block in Odessa, Ukraine, or in Kyiv or Kharkiv, that's a perfect example of what this rule is meant to catch by providing more information on these entities. But as you'll see as we go through this presentation, it's a pretty broad net that they've cast, and this really is a dragnet. So there's a lot of information that's going to get caught up in this. So starting from the beginning, reporting companies will have to file an initial report. This will include their full legal name, their trade or business, or their trade or doing business as designation, their current address here in the United States, and what jurisdiction they're formed under. This is for all American formed entities. If a foreign entity is registered to do business in the United States, basically they'll have to provide all the same information, but they'll have to provide information regarding where they were formed and where they are registered to do business, first registered to do business within the United States, and where their the bulk of their business activities in the United States takes place, as well as any taxpayer identification number provided by the IRS or foreign equivalent. Now, an entity would be a reporting entity if it has filed paperwork with a Secretary of State in a U.S. state or tribal or territorial equivalent in order to form here in the United States, or as a foreign reporting company, it's been formed in a foreign jurisdiction and has then filed a form in an American jurisdiction, essentially for the same purpose. So limited liability companies and corporations are expressly stated in the rule. However, limited liability partnerships, limited partnerships, and other entities would also be included. Now, note, this means that if you don't file paperwork in order to form the entity, it would not be included necessarily. So a common law general partnership would not be included. If you're not filing with the state, then you're not a reporting company. So what's required for an individual, which I think is the issue that is of most concern to many of the people on this presentation? Well, it would be their full legal name, their date of birth, their complete current address. Now, for company applicants, so these are folks that form entities as part of their business, it would simply be their place of business. For individuals who aren't company applicants, so the actual owners of businesses or those who exercise substantial control over them, this would be their individual residential street address. And we'll get to that a little bit later in the presentation, but there's less guidance on that than we would like. So you'll also have to provide a unique identifying number in the issuing jurisdiction. So think a passport, driver's license, or state or tribal issued ID, or a foreign passport, as well as an image of you from that document and an identifying number. So if you don't like your driver's license photo, I hope you like your passport photo or other identifying photo, because the government is going to want one of them. So when should the initial report be filed? We recently got some relief on this. The original rule provided for only 30 days for filing for entities that were created starting this year. Entities created 2023 and earlier would have up to a year to file. Originally, it was 30 days for entities created January 1st of 2024 and onwards. That was recently extended to 90 days because FinCEN realized that there was still a lot of compliance work to be done on the part of company owners. And quite simply, they also needed to get more information out to the public as well. If an entity is created after December 31st of this year, they will only have 30 days to file. And this is for American created companies, formed companies, and also foreign registered companies. So for domestic companies, and this is a theme that you'll see in the next few slides come up again and again, when does that clock start ticking for compliance? For domestic companies at formation, for the initial report, it is measured from the date that the entity receives confirmation that it has been formed or public notice has been given. So if you file with the state of Massachusetts and the Secretary of State's website shows the entity pop up that same day, it's measured from that date. If that doesn't happen and it's not listed publicly, then it is measured from the point at which there is confirmation by the Secretary of State or equivalent that it has been formed. For foreign entities, it is measured from the date when they first registered to do business within the United States. When it comes to entities that are no longer exempt, they will only have 30 days. So as you'll see later in this presentation, there are a number of exemptions. There's 23 in total, actually, that could apply to different entities who do not need to report beneficial ownership information. They don't need to report who controls them or owns them. However, if you fall out of the category or categories that allow you to be exempt, you will only have 30 days to comply. So make note of that. Most of them are, well, categorical, for lack of a better term. A few of them are more soft, and we'll get to that. But large operating company is the designation that I think provides the most risk when it comes to falling out of exempt status. Also, it's important to note that when it comes to company applicants, again, these are folks that register a company or form it as part of their business. They do not need to report this information for entities formed prior to January 1st of this year. So when you file an updated report, this is when information changes. So this could be exemption status, as I mentioned. So if you fall out of, if you were exempt at not exempt at some point, then exempt, then you fall out of exempt status again, you have to file an updated report. If you become exempt, you will actually have to file a report. Or if information regarding a company or its beneficial owners changes, then you will have 30 days. So this could be the principal address for a business. This could be its jurisdiction of formation or jurisdiction where it is in residence. This could also mean for an individual when their name changes or when their residential address changes. And there are some permutations to that, but this also would include changes to the identifying document from which the required identifying number is pulled from. If that document changes, you'll need to file an updated report. So you can already see that there's an ongoing requirement, not just to comply, but to stay in compliance. So a few other instances where that clock starts ticking. When is information deemed to have changed? So in the case of a beneficial owner who dies, the clock starts ticking for 30 days at the point when their estate is settled. So you can imagine that when someone passes, they have interest in a variety of different companies. It's not the point of their death when the clock starts ticking. It's after things are settled with their estate, because the estate is open to creditor claims. Presumably their heirs might not become members in LLCs or stockholders in corporations that this person, the decedent, had an interest in. They may sell their interest. The estate may sell their interest. So it's only after the estate is settled that this clock starts ticking. Because quite simply, you might need that much time just to figure out what will happen with them. So this makes sense. Beneficial owners who are minors are actually exempt from having their information reported, so long as a parent or guardian places their information on a beneficial ownership report in their stead. However, once that minor child reaches the age of majority, they need to file an updated report. So 18th birthday plus 30 days is the deadline for filing the updated report. So you can see how in certain circumstances, it may behoove a company to keep tabs on who owns interests in it, even if they're not involved, such as in the case with a minor child. And as I mentioned, if the identifying document for an individual or company, for a beneficial owner or company applicant changes, that will also trigger, and the clock will start ticking when it changes. And this is some examples from the rule are when the name, date of birth, address, or unique identifying number on such document changes. So keep in mind, if you use your driver's license as your identifying document, and it includes a residential address, and then you move, and well, when you move, you should file an updated report anyway. But when that driver's license changes, you need to file an updated report. Now, interesting to note, for the entity exemptions that we'll go over later, you also need to file. So if an entity needs to file, it's a reporting company, and it's been filing, just because it reaches exempt status doesn't mean that it drops off FinCEN's radar, or it can let itself drop off FinCEN's radar. It actually needs to file an updated report because the information has changed. If you find out that a report is incorrect, you'll have 30 days to correct it as of the date when you discover the inaccuracy or have reason to know of it. Now, it's worth noting that the Corporate Transparency Act provided for 90 days, measured from the day when the inaccurate report is filed. The rule says that if you file within this 30-day period of discovering it, you'll be deemed to have satisfied that 90-day requirement. And that 90-day requirement relates to criminal and civil penalties that could derive from filing an inaccurate report. And we'll get to a little later in this presentation what those actual penalties are. And I bet you thought that was going to be much later in the presentation, but it's right now. So when it comes to willfully providing false or fraudulent information, it'll be $500 per day, capped at $10,000 in civil penalties. It could also include up to 2 years in prison. It could be both, either or. When it comes to misuse of beneficial ownership information, the penalties are much more steep. So you can imagine situations where at a company, there might be a single individual charged with filing this information, with gathering this information from beneficial owners and those with substantial control in order to file these reports. You can also imagine that there are folks at FinCEN that are privy to this information, which is extremely sensitive. These penalties are very steep, up to $250,000 in fines or 5 years imprisonment. These are meant to deter bad actors from misusing this information. I think we've all probably had information leaked in a data breach of one kind or another from a public or private entity. I know my information has been breached from a government database. It was some years ago, along with about 30 million other Americans. So how safe this information is, you decide that for yourself. But FinCEN recently produced additional guidance on safe handling and access to this information. And again, there are provided in the statute some pretty steep penalties for misuse of this information. So, beneficial ownership generally. What does it mean to be a beneficial owner in the broadest sense? Well, it can be direct or indirect. And it can be achieved either through exercising substantial control over the reporting company or owning or controlling at least 25% of the ownership interests of the reporting company. A couple of things to note here. There are a lot of carve-outs here. So if you own an interest in an exempt entity, again, which we'll go over later, and then that exempt entity owns interest in a reporting company. So say you own an interest in, say, a bank, and you're a significant owner or you have substantial control over the bank. But then you wind up, the bank owns an interest in a reporting company. And I'm sorry, I said control. This relates only to ownership. So if you own, say, 25% of a bank, and the bank owns 25% or more in a reporting company, you don't need to file, your beneficial ownership information does not need to be filed by that reporting company. The reporting company would simply file the information for the exempt entity in that case. So having an exempt entity between you and a reporting company acts as a blocker when it comes to ownership. Something else to note, when it comes to pooled investment vehicles, they're generally exempt. They're one of the exempt entity types. However, pooled investment vehicles are not, but the rules are a little different for them. For pooled foreign investment vehicles, it's not the beneficial owners, the actual owners of the investment vehicle that need to report. It's merely the individual that has the greatest authority over the strategic management of the entity. So rules are a little bit different there. So when it comes to substantial control, what qualifies as substantial control? Let's define it extremely broadly. And again, this is a theme that you'll find again and again through this presentation. This is really meant to be a dragnet rule. They're trying to get as much information as possible. So an individual who exercises substantial control would be in any of the following ways, as you'll see on the screen, would be considered to have substantial control and thus be a beneficial owner. So this would be any senior officer. And the rule is pretty broad on describing this, but basically think C-suite or similar. So your CEO, your CFO, your COO, your chief counsel, your secretary, your treasurer, all of them automatically. If they have any control at all, or if they have substantial control, then automatically they fall under this requirement and they would have to report their information. Also, if an individual has authority over the appointment of senior officers or the appointment of a majority of the board. So you can imagine that individual is going to be extremely powerful in that organization. They would also be included. If they direct, determine, or exercise substantial influence over major decisions of the company. And there are 7 enumerated types of decisions in the rule. We haven't included all of them here, but a few basic examples are M&A, decisions around mergers, acquisitions, dissolution, but also major expenditures. So that level of control would also suffice to require someone to report. Or, and here's the dragnet, has any other form of substantial control over the reporting company. So if you think that you're very influential in the organization and have substantial, what you would think of in a general sense as substantial control, you probably need to report. So substantial control may be exercised directly or indirectly. So you can do this individually or as a trustee of a trust. So simply forming a trust, say a revocable trust, and then having shares in the company through that, owned by that revocable trust, is not going to act as a sufficient blocker. So if through, on your own or through a trust or some other similar arrangement, you exercise some control through board representation, majority ownership or control of voting rights, rights associated with financial arrangements. You control intermediary entities that are, say, parent entities, arrangements or financial and business relationships with individuals or entities acting as nominees. Or again, here's the dragnet, any other contract, arrangement, understanding, relationship, or otherwise. So what does an ownership interest include? Well, quite simply, anything that's an equity. So stocks, certificates of interest in a business trust, joint venture interests. And it's important to note that these don't actually need to be transferable and they don't have to come with voting rights. It's purely about ownership in this case. So if you have control over an entity, say you exercise all of the voting authority, you're automatically, you have substantial control, you're automatically a beneficial owner for purposes of the rule. But even if you're a silent investor and you can't get out of your investment and you're essentially powerless, but you own a significant portion, 25% or more of an entity, then you are subject to this rule and you need to report. It can also include capital and profits interests in a partnership, convertible instruments such as futures, warrants, or options, puts, calls, straddles, or other options or privileges of buying or selling the above interests. And keep in mind, when it comes to calculating how much of the ownership of an entity you have, there are rules that require you to essentially treat any convertible interests or options or similar rights as exercised. So if you have convertible interests that would, if exercised, would give you control of a company or at least a 25% stake, then you would have to file. And again, there's another catch-all when it comes to these instruments. Any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. Ownership or control can be exercised in a variety of different ways. So it can be exercised not just through outright ownership of such interests, but also through joint ownership of an undivided interest. It can be through a nominee, an intermediary, custodian, or agent, as the trustee of a trust, or in a situation where a trust is involved, as the trustee of a trust, as the sole beneficiary of the trust, as a beneficiary who may compel a distribution, or as the settlor or grantor of the trust who retains a right to revoke assets, the assets of the trust, or revoke the trust entirely, and also through intermediary entities. Ownership interests and control thereof. When it comes to the 25% rule, as I mentioned, you essentially need to calculate all of your convertible interests as having been exercised. The profits and capital interests in a partnership also need to be calculated. For corporations, you take the greater of vote or value. So if there are multiple classes of stock with different voting rights or different amounts of equity represented, you take the greater of the two in calculating whether or not you fall under or over the 25% threshold. And these ownership interests are otherwise calculated presently, but as mentioned, options and similar interest convertible instruments, these are calculated as though they've been exercised. So individual exceptions to this. Beneficial ownership does not include, as I mentioned previously, minor children, so long as a parent or guardian has placed their information on the report in their stead. Minor children thus could avoid having their information reported, but when they reach the age of majority, that ends and they have to report. Nominees, intermediaries, custodians, or agents also do not need to report. If you're a mere employee of a company and you're not a senior officer, you don't need to report. Rights of inheritance. So just because you're the heir to the owner of a company or the heir to a significant owner, beneficial owner in a company, that does not constitute a beneficial ownership interest that you hold, so you don't need to report. And creditors. Just because someone owes you money doesn't mean that you own them. So just because someone owes you money doesn't mean that you have to report your information. There are 23 entity exemptions, as I mentioned. I'm not going to go through all of them. They are summarized here on the screen. There are additional requirements to many of these. But securities issuers formed under the 33 Act and the 34 Act, government authorities, banks, credit unions, insurance companies, broker-dealers, venture capital fund advisors, accounting firms, and certain tax-exempt entities and tax-exempt entities supporting entities. There are a few that are of particular interest, though, if you fall outside of one of those categorical exemptions. So a large operating company is probably the exemption that many companies are going to try to claim. You can claim it if you have 20 full-time employees in the United States, or more than 20 full-time employees in the United States, and this is on a per entity basis for employees. Very important to note that. You have an operating presence of a physical office in the United States. Your most recently filed federal income tax return for the prior year shows greater than $5 million in US source gross receipts or sales reported on a Form 1120. So say for a corporation, a 1065 in the case of a partnership or something similar. Similar returns in a case where there is an affiliated group that files a consolidated returns, you can aggregate the amount of these of the gross sales or receipts, but you can't aggregate employees. And when it comes to the financial metrics, these are all going to be measured under the US tax code. So another exemption that a lot of entities may try to fall under is that of a subsidiary. So generally, if you fall under one of the other exempt categories and you're a subsidiary of that entity, you'll be able to claim exempt status. However, there are some exceptions to this exception. Subsidiaries of money service businesses, pooled investment vehicles, and entities that assist tax exempt entities would not qualify for this exemption. And then inactive entities. You have to meet all of the requirements on the screen in order to claim this exemption. So you would have to have been formed before January 1st, on or before January 1st of 2020, can't be engaged in any active business. There can't be any foreign ownership whatsoever, directly or indirectly, wholly or part. There's been no ownership change in the last 12 months, and essentially the financial transactions are minimal in the last 12 months, and there are no assets. So essentially it's an empty shell. If you've got an old LLC that you formed 5 years ago or more, and it hasn't done anything, it doesn't have any assets in its name, it doesn't do anything, your cousin from overseas has no ownership interest in it, there's no foreign investor involvement, then that entity could avail itself of this exemption. But otherwise, you would not be able to fall under this. Keep in mind that if an old entity that meets these requirements does suddenly start doing things again, say you fund it with assets, you contribute property or money to it, you have it engaged in financial transactions, you change ownership, then in that case, you would no longer be exempt and you would have to file an updated report within 30 days. When it comes to some other topics that might be of interest, as I mentioned, residential address is not as specific as one might like. When it comes to the rule, it says residential address. FinCEN in the comments to the final rule when it was propagated back in 2022 noted that the address used for tax residency purposes, that they would decline falling back on that as the definition for a residential street address because they found that it was not as clear or certain as they would have liked. So something to keep in mind is you are supposed to list your current residential street address. FinCEN has provided some further guidance for individuals that don't have a permanent residential address. They are supposed to file their current residential address. For folks that have multiple residences, second homes, FinCEN has not provided as much guidance as we would have liked. So this is something that you should we're keeping an eye on. This is something to consider. When it comes to converted entities, FinCEN did say in the commentary to the final rule that they would consider offering guidance on how converted entities should be treated and how they should be handled. Because presumably in a situation where an entity converts and it has to file with the Secretary of State, its status has changed. FinCEN has not provided that guidance yet. This is, again, something that we're monitoring. But if you move an entity to a new jurisdiction or you reorganize it, say from an LLC to a corporation, or you move it from, say, Texas to Alabama, then you should file an updated report because fundamental information about that entity has changed. And then when it comes to access to BOI, as I mentioned previously, FinCEN has provided additional guidance recently on safeguards for BOI information. And that's outside the scope of this presentation, but they are trying to provide some additional safeguards. The Act and the rule both contemplate a system for maintaining the security of this information and constraining access to it. again, as someone who had their data breached from a Department of Defense database, as 30 million other Americans did, I don't trust that this information won't get hacked at some point. But it is what it is. They're trying. So at this point, I'd like to open the floor to questions.
Michael, thank you. I know that Chad Gottlieb has already been on and in the Q&A room addressing some of the questions we've already gotten. And while he goes through those, I think I'll just take one from the chat. Are you able to see that, or do you want me to read that to you?
I actually have the chat up in front of me. I guess the broader question is, can you guys see the chat on my screen when I've got it open?
Oh, no, the users cannot see it. So you'll just have to restate the question so that everyone has the ability to know what you're talking about.
Okay, excellent. And thank you. All right, so one good question that we've got here, does exemption mean do nothing, or is there a form to file that states the reason for the exemption? So you have to file that you're exempt. If you become exempt, then you actually need to file. The rule contemplates that expressly. So if you become exempt, you have to file. If you are no longer exempt, the rule also expressly states that you need to file. So you're going to wind up filing a BOI report in any case. So that is, you actually need to claim the exemption. If you're exempt from the beginning, you don't need to do anything. But if you fall out of exempt status, then you would need to file an initial report. Some entities, I imagine, with a large operating company exemption may fall in and out. You may find that for a given year, you have 19 employees, and then all of a sudden you need to file. Or you previously met all the requirements, and then there's a drop in revenue or gross receipts because the economy slows down, and then you need to file. But then the following year, you're exempt again. You then need to file again. So some entities are probably going to find that they have to file for exempt status and then fall out of exempt status and file updated reports again and again. But if you're exempt from the very beginning, you don't need to do anything at this time.
Very good. And then in the question and answer box, Michael, there are some questions in there. If you can just go to the open questions tab, you will see those that need to be answered.
Oh, excellent. Fantastic.
All attendees are able to see that, but I do think there's value in just restating their question.
Certainly. I appreciate it. So another question, are these requirements and or any one item creates an exemption? So if you fall into, so it works differently. So remember, there are exemptions for certain types of individuals. There are exemptions for certain types of entities. If you meet the requirements for a given categorical entity exemption, then you meet the requirements. The requirements are actually specified in the rule. So I didn't post the full requirements on the screen because some of them were actually quite lengthy in reference to other statutes. So for the sake of summarizing things, I left those off. But for instance, if you're a bank organized as say like Bank of America, they don't need to file. Or for a public accounting firm, they wouldn't need to file. So, but you would have to look into the exemption requirements themselves for each type. For the large operating company requirement, again, all of the requirements need to be met. You need to have an office in the United States. You have to have at least 20 employees that are in the United States. You have to have more than $5 million in gross revenues or receipts for your most recent tax return. So, and then when it comes to exempt entities, you also have to meet all of the requirements. You basically can't be doing anything, have any assets, have any foreign owners of any kind whatsoever, no matter how far detached, and been formed on or prior to January 1st of 2020. So Some of the other exemptions include or clauses, but you'd have to look, if you're trying to claim an exemption, you really need to take a close look and see if it would apply to you. And for what it's worth, we're also happy to do that for you. If you have questions as to whether or not you're exempt, we're happy to look into that for you. You can reach me or anyone else on the BOI CTA group here at DarrowEverett. After this presentation, we'd be happy to answer any questions for you. So when it comes to, all right, so there's additional question here. Point of clarification, not all accounting firms are exempt, only firms that are registered with the government in accordance with SOX. Yeah, so again, you'd have to look at the particular requirements to see if your accounting firm actually falls within that exemption. And you could also find that you fall within an additional exemption as well. I imagine this will probably happen with a lot of companies. So if you're a large company and you have hundreds of employees and tens of millions of dollars in revenue, you don't have to worry. Even if you don't fall under any of the other exemptions, the large operating company exemption would cover you. Another question, does exempt mean no need to file, or does it mean there is a form? That one came up previously, my apologies. If an entity in existence prior to 2024 dissolves before the end of 2024, does the entity have to file a BOI report? That's an interesting question. Before the reports are actually due, if they no longer exist, likely they don't. FinCEN has not been great about providing additional guidance. Are there any updates on homeowners / community associations and board members needing to file? So if you have, that's an interesting question. That's probably like a home ownership association is obviously outside of what's contemplated by the rule in terms of its purpose, its stated purpose at least, unless the local homeowner association is shuttling microchips to Iran and Russia or money laundering. I have not seen any guidance on this, but when it comes to the entity itself, if you exercise substantial control over it, so say the homeownership association files paperwork with the state and thus would be a reporting company, they would have that requirement. Then in that case, the individuals that exercise substantial control over it would presumably need to file at a minimum. So if there's whoever's in charge, controls finances, etc., they would presumably need to file. But again, FinCEN is still providing guidance on a lot of these smaller questions. So this is something that we're keeping an eye out for. Expanding on the pooled investment company exemption, would that include, say, private credit funds, private equity funds, hedge funds? Does that also include an investment vehicle that was set up with multiple investors to invest in one specific company in a GP-LP structure? This is a fantastic question. So when it comes to the pooled investment vehicle exemption, again, the rule for a lot of these exemptions, well, the rule for every single one of these exemptions elaborates on the requirements to meet the exemption. So you would have to be in compliance with that. And if it's a foreign pooled investment vehicle, then you would still have to report. It would just be for whoever has the most control over it. For a particular structure, keep in mind that other entities may need to be reporting companies nonetheless. So subsidiaries of that entity may not fall within the subsidiary exemption. I believe the pooled investment vehicle exemption does not apply to its subsidiaries. So keep in mind that there's still going to likely be reporting requirements. And if you're interested in our analysis of a particular structure, we'd be happy to take a look at it for you. And again, you can reach us. You can reach me at my DarrowEverett email at mraposa@DarrowEverett.com. You can also reach the other members of our team by emailing our CTA BOI email team.
Michael, we've gotten through all of the questions. That's great. Thank you so much. Do you have anything additional to add? Just some final thoughts for all those in attendance.
Not really, aside from the fact that FinCEN is still providing guidance here and there on different topics as they crop up. I've reached out to them a number of times to get clarity on some issues. So we are monitoring the situation. So if you have questions for us, again, feel free to reach out. We're happy to assist. And if you have particular questions regarding your particular business or your particular situation, again, we're happy to look into that for you. And we can also assist with filing in general. So.
Superb, Michael. Thank you. And to all attendees, again, thank you for coming. We really appreciate you. Just so you know, we will be making our PowerPoint available to all those who have signed up to be in attendance today. And also, we will be posting the video of our webinar that will be on the multimedia resources page of our DarrowEverett website. So again, just thank you. If you have any questions, just please reach out to us at DarrowEverett, the attorney that you routinely work with, or at any of the numbers of our offices listed on our website. Thank you again, and take care on this Tuesday.
Thank you, everyone.